don't see how you're winning anything there. But I wanted to talk about some emails that have surfaced, and this is pursuant to the litigation between the Freemans and the Yuma Airport Watchdog website, Mr. Gomez. And to put it simply, I'm appalled by some of the stuff I'm reading in here. There's a level of interaction between the Freemans and the airport director and airport staff that even I would have been, would never have guessed. But there's one email in particular here I'm reading, and this is November 23rd, 2011. This is from the airport director, Mr. Williams, to the Freemans, in which he takes it upon himself to give tax advice from his brother, Mr. Williams' brother, a retired IRS auditor. And he's given tax advice to the Freemans. I'm talking about, they can collect money from Joe Gomez by filing stuff with the IRS. And he says it's a clever idea from his brother. And I really have to question this. This is litigation between the Freemans and Joe Gomez. I don't understand why the airport director would get involved in that and take a side on that and be giving tax advice to the Freemans. I'm sure they have plenty of accountants. And this takes me back to the point where he went to where I work because I talked about the airport on the radio show. And it's the same type of behavior. And it's appalling. And I wish this board, I really wish, you would understand when airport staff does stuff like this, it's representing you folks. That's all I have to say. Thank you.
Good job.
So with this
Executive
Okay,
session.
let's go to the next agenda item.
Are you through with the call to the public?
Is there any more comment?
Yes,
Okay.
I do. My name is Tom Trotter. I'm GA, General Aviation. In the Yuma Sun, the headline of back, we fought this thing about open meeting laws and what you understand about it, what you don't understand about it, what you're posting, what you're not posting. This is December 23rd of 11. It happened 2 days earlier. Open records law always kept confidentiality. State public officials must prove burden of privacy. Phoenix, Arizonians are legally entitled to know what public officials have been doing, even if it's only going with the security details of the cleaners. The State Court of Appeals ruled Thursday. In a decision wide-reaching implications, the judges unanimously concluded the requirements of Arizona law for open records outweighs any general claim of confidentiality. The judges said public officials and the security officers who protect them are entitled to withhold certain events or details that could pose a security risk. But they said the burden is on the public official to prove that risk, not on the person soliciting the records to prove otherwise. And the court said the fact it would be inconvenient to go through records to figure out what is and not subject to disclosure is insufficient to deny the entire record to the public. The new ruling involves a dispute between Judicial Watch and the City of Phoenix over the details of the activities of Mayor Phil Gordon. But the decision, unless overturned, has statewide implications. It also comes amid perennial requests by various media outlets to get specifics on the activities of Governor Jan Brewer. Those, however, have been met with governor's staff saying the public is entitled solely to a list of events which are open to the public. But Brewer is not alone in that attitude. Governors from both parties have denied similar requests for years. Gregory Collins, who represents Judicial Watch, said the ruling is significant. This case, I would think, stands for the fact that government needs to be transparent. He said when the government isn't transparent and it doesn't tell the public what it's doing, that's what the court system is for. City attorneys had no immediate comment. Judicial Watch sought to the activity logs created by police departments detail assigned to protect Gordon from the time he leaves home each morning until he returns. City officials agreed to make the mayor's calendar available, but they refused to provide detailed logs.
Question, please. What point are you trying to make?
The point I'm trying to make is every time that you have a meeting, you're operating under the open meeting law, which is a state law, which is that very law right there, and every meeting that you've had, and the posting of records, I sat through a meeting here just 2 weeks ago that was discussed of what you was going to do, what you're not going to do. If you'll read the law, it says what you'll do, and you will do it. You will do it in spite of everything. The county attorney, I've got 2 complaints in now, and every time that you guys don't post what goes on in these meetings, I will file another complaint, and it will go to the Attorney General. You have to have open records. You've got to tell the public you are a public entity. And the law says it. It's the legislature, everybody that is public operates under the same rules and order.
Are you done?
If there are any other questions.
Are you done? Anybody else? We have the minutes from the February board meeting. Any questions or corrections to the minutes? Second. Motion, we have a second. All those in favor? Aye. Opposed? Thank you.
We have a visiting attorney with this meeting, and so normally we hold our executive sessions at the end of the meeting, which allow him to brief everything that we need to know and then get back. I would like to go into executive session at the first meeting this time.
Okay. Motion to go into executive session. Second. We'll go into executive session. All those in favor?
Aye.
All those opposed? I'm opposed. All the ayes have it. Clear the room, please.